Listen carefully, ladies and gentlemen. This is the weekly recap of all the top stories throughout the week, conveniently located in one location, right here. Weekly recap. So don't leave me a comment saying this is old news. It's a weekly recap. Enjoy it. Have a wonderful day. We'll see you next time on Crime Talk. Quadruple murder suspect Bryan Kohberger has started his extradition process back to Idaho, actually having left Pennsylvania about 6 a.m. this morning. Let's face it, they were going to put him on a nice, comfy airplane, and if he's not back into Idaho by the time this video goes up today, he will be there shortly. We do know that he left the Monroe County Correctional Facility after he waived extradition yesterday in his hearing, and he is expected to be taken to the county jail there in Moscow, Idaho. Now, apparently, Mr. Kohlberger mouthed "I love you" to his mom while he was in the courtroom, and his sister was also there comforting his mom. And what we do know is that the warden, a guy by the name of Gary Hadel, confirmed that Kohberger is no longer in their custody, and he is on the move. It's understood that Mr. Kohberger will be transported via plane back to Idaho, arriving today. And somewhat surprisingly, the court in Idaho, sua sponte, which is a fancy Latin word that means on their own motion, basically, issued a gag order for the Moscow police and the legal teams in regards to this case, barring anyone linked to this case about talking about the case. Now, the prosecutor, Bill Thompson, said that once he, Mr. Kohberger, gets there, he'll have an initial appearance with their magistrate. The affidavit will be unsealed, so we'll be able to get the information that we believe is going to show what evidence they have, the strength of the case, and clearly evidence to establish probable cause because a judge signed the order. But the question will it be enough to prove the case beyond a reasonable doubt? Now, I have spoken to some people that represent to me that they are familiar with the case, and they're clearly going with the theory that Mr. Kohberger was angry and upset because Miss Gonsalves, or perhaps one of the other young ladies, rebuffed some advances, and that they really wanted this car because although they believe it had already been detailed shortly after the killings, that they're hoping to find some blood DNA evidence, hopefully within one of the crevices of the floor mats or something along those lines. Take that for what it's worth. The person that I spoke with seemed credible, but we'll never know exactly until the affidavit is unsealed to see what they have for evidence against Mr. Kohberger. Now, obviously, Mr. Kohberger will get counsel when he arrives, and guess what? He's already stated that he is indigent. His parents have stated that they don't have the resources to defend their son in a quadruple homicide, and therefore the public defender's office there in Idaho is going to work. And apparently there is a 5-person strong team of investigators that works for the public defender's office or were privately retained, and they already have gone to the house where the slayings took place. Now, some people are saying, oh, that's unusual for the defense attorneys paid by the state to reconstruct the crime scene or go to the crime scene. No, it's not. No, it's not. Hire crime scene reconstruction people, not on every case, but a big case, certainly something you look into. And clearly, if you can get access to the house, the crime scene in this particular situation, before it's been released, before the reclamation process takes place in the house, the cleaning, the removal of rugs, etc., that is a benefit to the defense. They can take their own photographs. Maybe there's something that the prosecution overlooked. Pretty unlikely in a case like this, but you assume nothing in a homicide investigation. And I mean that. It's the best way to operate. Assume nothing. If somebody says they saw A, you go talk to them to make sure they really saw A, and you go ask them how certain they are. you go to the crime scene. That's the best way to get a feel for any case. I've said this before and I will say it again. Any good attorney knows most cases don't turn on the law where like, oh, the statements are going to get thrown out, the search is going to be thrown out. It usually comes down to who can find the best facts. And Mr. Kohberger's public defenders are already on the move at the property there on King Road. Now, let's be clear. Some people are going to say, oh, it's a public defender. Don't ever say that. I'm telling you, some of the best attorneys I've ever seen have been public defenders. Some of the best I've ever seen have been private practice. Some of the worst attorneys I've ever seen have been public defenders, and some of the worst attorneys I've ever seen have never been a public defender in their life. It just depends. But the public defenders that stick around, the ones that are there for the long haul, not getting paid an exorbitant amount of money, having cases stacked up a mile high, literally could be carrying 150 cases at any given time. They are the true believers. They're not there for the money. They're making sure that people's constitutional rights are being protected. So let's make sure everybody, nothing better in a good case than good lawyering taking place. So that's good. And if there's a guilty verdict, all the better. Why? Because if they've had strong, effective, competent counsel, then post-conviction relief is not going to be an issue down the road. This investigation team from the public defender's office apparently spent about 45 minutes in the home today taking video footage both inside and out. Four of the investigators ultimately left the property, but somebody believed to be a crime scene reconstructionist remained, which just simply means they were probably taking a few more notes and diagrams. But it's all been photographed, measured, documented. It's all going to be turned over by the prosecution as well. So they'll get it all anyway. So like I said, the affidavit for arrest warrant should be unsealed shortly after Mr. Kohberger appears in court, so we'll get to see what they have. Now, one of the first assistant district attorneys confirmed that they believed Kohberger is desperate to return to Idaho to find out the affidavit's contents. Well, I mean, certainly if you've been accused of a homicide involving 4 individuals, you'd probably be a little curious to know what evidence they're claiming as to why you did it. That comment may have been one of the reasons why the judge on their own issued a gag order. You can't go ahead and comment like that. Oh, he's so eager to find out what's going on. That's, I don't know, that's like ethics 101 in that regard. So as we do know, Mr. Kohberger, who is this graduate student, was driving across country with his father. And we also know that it was confirmed that he had been pulled over twice for driving too close to a car in front of them in Indiana. We put up the body cam footage. You can see here that he is in the car with his dad on December 15th on I-70 just outside of Indianapolis. During the stop, Kohberger's father appears concerned that the officer asks for his license and registration. I don't know if I'd read too much into that. You know, you're kind of just curious as to why, what's going on. Anyway, a sheriff's deputy had stopped him earlier the same day for following too close. Investigators apparently started tracking Kohberger's movement across the United States, with witnesses claiming that they saw both him and his father getting repairs done. Possibly a detail on the car, perhaps? We'll have to see how that information pans out. Now, I'm going to take a guess. I somehow don't think that he was randomly pulled over for following too closely or speeding, anything along those lines, as it relates to him going across country. I've had many clients that have engaged in some alleged criminal activity that randomly get pulled over. Who would have thought? What a coincidence. I somehow think it will come out throughout the process in discovery that they were not just randomly pulled over. Just saying. What are the odds? I don't believe in coincidences like that. It could have been when they were asking for his license to see if, you know, maybe they could perhaps swab it, perhaps. Who knows? We will have to wait and see. Now, the other thing that's going to take place here is that everybody that's ever known Mr. Kohberger, and you've seen it all, the neighbors who are shocked, the kid who went to high school with him, he said he was mean to him, they're all popping out of the woodwork. Generally, guess what? Don't care. Don't care. Why? Because it's not relevant whatsoever. Unless you can show that Mr. Kohberger has maybe killed 4 other people with a knife, as he's alleged to have done here, then it would potentially be relevant under 404B evidence, but otherwise don't care. Not important, not going to be admitted in court whatsoever. I know everybody's looking for a story in this particular case, but the guy that he was mean to in 6th grade, really don't care. Not relevant. Nobody should care. Just saying. If I offended somebody, I'm sorry, but don't care. Now, there have been reports that apparently Mr. Kohberger, even while back in Pennsylvania, was walking around wearing gloves everywhere he went. And of course, the speculation is that he was trying not to leave any DNA or fingerprints anywhere. You know, so like when he was done drinking out of the glass, somebody could come and take the glass and get the DNA, maybe to test it as it relates to potentially known sample or a family genealogical DNA test, so they could kind of work backwards and see if he is a potential suspect. Just saying. I don't know. There's a lot of stuff going on right now. Let's wait for the real facts to come out.
Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked.
Well, Bryan Kohlberger was denied bail today, not surprisingly, during a very brief, short court appearance that we brought you earlier today. And also the affidavit detailing the prosecutor's case was also shared. Now, Mr. Kohberger spent most of the 10-minute hearing looking directly at Judge Megan Marshall as she read him the charges and the possible penalties and advised him of his rights as it relates to the 5 counts where he responded yes, that he understood each of the charges against them. He will return to court on January 12th for a status hearing. Now, I read to you verbatim the affidavit for the arrest warrant earlier, and frankly, I think we did it pretty flawlessly. A couple of times I had to start over, I'm not going to lie. But the point is, we read it word for word. We can summarize it, but I really think it has to be read in its entirety to get the whole context of the investigation. But what we do know is that Kohberger's DNA was found on a button on the knife sheath and it was close to the bodies of Maddie Mogen and Kaylee Gonsalves. Now, the affidavit also details how a surviving roommate, Dylan Mortensen, came face to face with the perpetrator, who she described as a masked man, who everyone believes to be Kohberger, in the hallway of their shared home around the time of the killings, shortly after 4 a.m. on November 13th. It states in the affidavit that Mortensen heard what she believed to be her roommate's cries. She left her room and saw a man in a black mask with bushy eyebrows and 5'10", maybe taller, and she froze with fear and watched as he walked past. Then she waited 6 hours before calling the police. Now, there's additional details that Kohlberger allegedly stalked the victims was shared. His phone was found to have been near the residence there in Moscow on at least 12 different occasions, starting back in mid-August. Now, the phone was apparently turned off at the time of the alleged killings, but there's video evidence basically detailing the travels, as the police allege them to have taken place, from video cameras both at the Washington State University as well as traffic cameras throughout the city and on the highways. Very interesting. And just as the police suspected, although the phone was off that night, it doesn't mean that he wasn't, for lack of a better term, stalking or casing the joint beforehand. So unless Mr. Kohberger has a legitimate excuse as to why he was there, like maybe he was tutoring up the street, he's got some explaining to do. Obviously, the DNA is going to be the biggest problem for sure, but as I said, go listen to the video. We will put a link in the video so that you can have the entire affidavit for your own edification. Now, if convicted, Mr. Kohberger faces the death penalty for the murders there in Idaho of Maddie Mogan, Kaylee Gonsalves, Zena Kernodle, and Ethan Chapin. And like I said, probably the toughest evidence he's going to have to overcome is the DNA sample taken from the button on the knife sheath, and then they match that with some DNA from trash in Mr. Kohberger's family residence there in Pennsylvania, which they were able to test in one day, and they were able to make that match. Now, the sheath is described as a tan leather United States Marine Corps Kohberger insignia stitched on the exterior. Can you imagine when he allegedly realized he left that behind? Oops. Yep. Anyway, go check out the link. Listen to the entire affidavit. All right, let's move on to another case in Idaho. I don't know. Is there something in the water out there lately? I don't know. Anyway, well, Lori Vallow and Chad Daybell are charged with the deaths of the children, JJ, Tylee, and then the death of Chad Daybell's wife, Tammy. They're scheduled to go to trial here in a couple of months, but the defense indicated that they weren't going to be ready. And now Mr. Pryor, on behalf of Chad Daybell, has formally filed his motion to continue. And why, you may say? It's basically that he cannot reasonably be prepared. He states that the mitigation process really has not gone the way he would like it to, in the sense that he's been too busy to do what he needs to do. And hey, have we mentioned this is a death penalty case, so you're entitled to basically super hyper due process. And Judge, there's just simply no way. And oh, by the way, Judge, have I mentioned that the prosecution still has not turned over all of the discovery in the case, and therefore, how can I possibly prepare until I have everything? And he states, which just shocks me to death, is that the mitigation investigation has only begun, and that if they were to go to trial in April of 2023, that would violate his constitutional rights, because Mr. Daybell would not receive effective assistance of counsel. My first thought is, what has been going on for the last 3 years? That's all I'm saying, okay? I get it. It's a big case, lots of discovery, etc. But at the end of the day, it's not really that complicated. By now, he knows what evidence the prosecution has, what they're going to use. He's aware. He's talked to his client. He knows what factual investigation is needed to take place. And literally, every time you have a case, you're always working on mitigation. Asking the client, tell me your story. What's going on in your life? How did we get here? Was there drugs, alcohol, abuse, something that maybe explains what may have taken place, how we got here? Maybe not a defense, but mitigation, something that may reduce the culpability or possible sentence in the case. Why is this not getting started now? Now, curiously enough, Mr. Pryor had indicated that he had asked for a second attorney to join the case, and this attorney was going to need to be up to speed. However, in this motion to continue, Mr. Pryor does not make any mention of that. He basically just says he cannot be ready to proceed. And as you may recall, we brought you the motion that was filed that he said, hey, Judge, you want us to have these juror questionnaires by January 9th. And that date just seems so arbitrary and capricious. You just made it up, pulled it out of thin air. There's no way that we could possibly be ready. Well, guess what? Judge Boyce made an order regarding the defendant's objection to the
order going back to December 16th. And the court basically says on December 16th, this court entered a scheduling order establishing certain deadlines ahead of trial to begin on April 3rd of 2023. On December 23rd, 2022, Mr. Daybell filed an objection to the December 16th, 2022 scheduling order and requested the court to vacate the January 9th deadline. As noted in the objection, the court has scheduled the deadline of January 9th for counsel to submit proposals relating to the questionnaire that the court intends to utilize in the jury selection process. And then the court goes on to state that this is reasonable, and it's the court's job to make sure that there is a fair and impartial jury here that takes place. And then the court goes on into the analysis part of his order, basically says, Daybell notes that this court previously found good cause to continue the trial from January 9th of 2023 in the memorandum decision and order entered October 28th. Central to the determination to find good cause was the mandatory stay of the Fremont County case, which is Lori Vallow's case, regarding legal competency issues. And Vallow had not waived her right to speedy trial, and any good cause previously found to continue the trial on that basis was abated. Daybell then refers to the court's conclusion the defense has indeed demonstrated that it is not and cannot be ready for trial in January 23 as justification by the January 9th deadline. The court then notes, you know what? The initial deadline for those juror questionnaires was October 14th of 2022. It was only the day before October 13th that the deadline was vacated. The court would expect that the proposed questionnaire would have been substantially complete given the timing. Further, the issue of questionnaires has been before all parties since well before September 23rd. The parties are also aware that the questionnaires will be used in jury selection, and the proposals from counsel are a concession to allow for their adequate input. However, it is ultimately the responsibility of the court to qualify and seat a fair and impartial jury who will collectively be prepared to render judgment as to the facts of this case. Thus, while trial counsel has been provided an opportunity to provide such input, it's not ultimately the parties but the court's obligation to determine the contents of the questionnaire. Therefore, the January 9th, 2020 deadline was not set arbitrarily. It was carefully selected after coordinating with the Ada County to provide adequate time to employ the questionnaire, which is a substantial task. Extending that deadline would necessarily complicate that burden and may result in the inadequate time to implement the important trial tool. The court does not find persuasive Daybell's argument that the development of mitigation evidence requires an extension of time. Counsel will still be provided an opportunity to conduct a voir dire at trial. This issue to be covered by the questionnaire are more limited in scope, and that was suggested in the objection. Given the substantial time that the parties have known for the use of the questionnaire, good cause to extend the deadline has not been demonstrated. Accordingly, the deadline remains. Counsel may choose to comply and supply the court with its proposed questionnaire or elect to let the deadline pass without submitting a proposal. In either case, the court will be the ultimate arbiter of a jury questionnaire and will do its duty to guide and protect the court and fairness of the proceedings. What has taken place with Judge Boyce there in Idaho? Maybe it's the New Year's resolution. Listen, the judge is not wrong. The court usually has its own questionnaire, and if you want to propose something, you have a deadline. You have to submit it. If you don't submit it, you waive it. I guess that's an ineffective assistance of counsel issue for Chad Daybell if he is ultimately convicted. But I like Judge Boyce saying no. So does that mean the trial date may get continued? We're going to have to wait and see. Why? Because the court can say, I'm going to hold you to this date, and jury questionnaires can be tweaked down the road. But I'm kind of liking the new Judge Boyce that we're seeing here. Hopefully he's going to say, no, we're not going to continue the trial. We'll see you in April. Of course, what's it going to depend upon? The prosecution. The prosecution wants this case set out much, much farther than April. So we'll see what the prosecution's position is, because they will have to respond to the motion filed by Chad Daybell. Now, the attorneys for Lori Vallow have filed some additional motions as well, and they want to declare the Idaho capital punishment scheme unconstitutional. And basically their argument is it's saved for the worst of the worst cases. This is different than the motion that they filed last week. And they specifically note that Mr. Archibald has had 26 defendants charged with murder that he's represented. 9 of those cases, the death penalty was pursued, and of those 9 cases where it was pursued, only 1 defendant received the ultimate punishment, and that was a guy by the name of Tim Dunlap, to whom he was assigned to resentence him some 14 years after his crime. And Mr. Dunlap has already received the death penalty twice before, once by a judge in Idaho and another by a jury in Ohio. Again, in support of their position, he's still on death row 31 years after his sentence was imposed. So, death penalty, good, bad. I'm mixed. Clearly, under the Constitution, it provides for it. The states can have their sentencing scheme if they want to, as long as they comply with federal law. So I get that. Then the issue becomes, is it more expensive? Does it ever really get implemented? That seems more of a policy question. How do you speed it up? How do you make it more fair so that it's not done arbitrarily? Or it seems like, most of the people are perhaps poor minorities that have the death penalty imposed versus rich white people. Lots of arguments there. Let me know in the comments what you think. Should the state just drop the death penalty and let's get this trial over with and move on? Or should they continue to pursue it? Anyway, we will have a hearing again on January 19th, 2023. Lori Vallow. We'll let you know what happens there in regards to the motions hearing as it relates to invalidating the Idaho death penalty system. Somehow I don't think that's going to work out too well for Lori Vallow and her attorneys. And seems like Lori Vallow wants to go to trial. Chad Daybell wanted to go to trial. He just didn't want to go to trial with Lori Vallow. We'll have to wait and see.